Computer. There we go. All right, looks like the recording has gotten started, so I'm going to switch to speaker view here so you're not looking at 15 pictures at once when the recording goes up on the web. My name is Jacob Schlosser. I'm going to start this meeting by doing a quick introduction to our chapter of the Federalist Society, introduce our speaker, and then let him take it off from there. So the Federalist Society for Law and Public Policy Studies is a national group of conservatives and libertarians. These are law professors, lawyers, judges, and law students interested in the current state of the legal order. It's founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. Channeling Justice Marshall there, and to that effect, I want to introduce our speaker tonight, Timothy Sandefur, who's going to be talking about Frederick Douglass, his constitutional thought, and his book, Frederick Douglass, Self-Made Man. Timothy is the Vice President for Litigation at the Goldwater Institute, and he also holds the Duncan Chair in Constitutional Government there. He litigates important cases for economic liberty, private property rights, and free speech in states across the country. He's the author of several books, including Frederick Douglass, Self-Made Man, Cornerstone of Liberty, Property Rights in 21st Century America, Permission Society, The Conscience of the Constitution, and The Right to Earn a Living, as well as dozens of scholarly articles on subjects ranging from Indian law to antitrust, slavery in the Civil War, and political issues in Shakespeare, in Greek drama, and of course in Star Trek. He's an adjunct scholar with Cato Institute and a graduate of Hillsdale College and Chapman University School of Law. With that, Mr. Sandefur, take it away.
Thanks so much, and I'm glad to talk about Frederick Douglass, and particularly about his constitutional thought on a couple days after the day that Douglass chose to celebrate as his birthday. The story is that Douglass decided to celebrate February 14th as his birthday because, of course, Douglass was born into slavery, and the last time that he could remember seeing his mother was when he was 7 years old. He had been separated from her, as was common treatment of slaves at the time, and was sent to live with an aunt, but his mother would come and visit him sometimes. And his vague memory from when he was 7 was that one day she came, actually it was during the nighttime, she came to visit him when he was really hungry, and he remembered her giving him a heart-shaped ginger cake to eat. And he vaguely recalled her calling him her Valentine. And he put it all together and thought that probably, since it took her she had to walk a long distance to visit him, and that's why she came at nighttime, that perhaps she would come up to visit him on his birthday. And he had some clues that he was born in February, so he put it all together and assumed that she had come to visit him on Valentine's Day, and that therefore his birthday was February 14th. So he celebrated that as his birthday. Not until he was an old man did he learn that he was born in 1818 instead of 1817, as he had long believed, because of course, accurate records were not kept of slaves' births and deaths. Douglass was, when he was 7, he was sent to live with some relatives of his owner, Hugh and Sophia Auld, who lived in Baltimore. And he was sent there to be a playmate with their son, who was also about the same age. And he lived in Baltimore for several years as a young man. And while he was there, the famous incident occurred when he learned to read. You've probably heard this story or read about it in his narrative that a lot of people read in high school. The story is that Sophia Auld thought she was doing a good thing by teaching young Frederick how to read the Bible. And when her husband found out about it, he was outraged and said that it would make him unfit to be a slave. Douglass later said that this was the first anti-slavery lecture he had ever heard, and he pledged at that moment to learn how to read. So he tricked the white children in the neighborhood into teaching him how to read. He would do things like dare them to write out the alphabet. He would say, I bet you don't know how to write out all the alphabet. Now I do too. And they would do it, and then he would copy it down, and things like stratagems like that so that he could learn to read. When he was a teenager, by that time he had become so hostile to slavery that his owners decided, or his master, Hugh Auld, who did not technically own him, decided to send him to live with his brother-in-law, Thomas Auld. Now, Douglass had, by that time, this was 1830s Baltimore, he had managed to get hold of newspapers and pamphlets that were being published at the time, many of which included speeches and attacks on slavery. Probably the most interesting of these were the speeches by John Quincy Adams, who was at the time serving as a member of the House of Representatives. He had been president, he went back to the House of Representatives, and Congress was receiving petitions against slavery, which the Southern representatives did not want Congress to consider. So they got a rule passed prohibiting the House from receiving petitions against slavery. John Quincy Adams, who was in his 70s at the time, stood up and announced that this violated the First Amendment, which guarantees your right to petition the government for a redress of grievances. And from that point on, Adams would repeatedly try to introduce petitions against slavery. He would get up every petition day and say, I have a petition here against slavery. The speaker would bang the gavel and rule him out of order, and he would go and do it again next week. This reached a crisis within 7 or 8 years of Adams doing this, when Congress tried to throw him out of the House of Representatives for introducing a petition calling for the dissolution of the Union. The Southern representatives were so shocked that anybody would ever suggest such a thing. They tried to have him thrown out of Congress. It's a remarkable story. It's told in a great book called Arguing About Slavery by William Lee Miller, and I very much urge you to read this book, one of my favorite books of all time. Very dramatic and interesting story. Also, if you haven't seen the film Amistad, that's directed by Steven Spielberg, it's a fantastic film about John Quincy Adams in another incident around the same time when he represented a group of Africans who were suing for their freedom after they had overthrown their captors. A great film, and it really a nice tribute to an unsung hero of American history, John Quincy Adams. Anyway, this was going on while Douglass, as a teenager, was living in Baltimore, and he was reading about it in the newspapers, and it really sparked his hostility. You know, he always felt an innate hostility to slavery, but this really got him thinking about the issue, and as a result, he became rebellious in a sense, and so he was sent to live in the countryside with Thomas Auld. And Thomas Auld was a very bad master, kept Douglass hungry, mistreated his slaves, so Douglass became even more of a discipline problem, according to Thomas Auld. So Auld sent him to live on a farm with a man named Edward Covey, probably the most famous incident in Douglass's memoirs. Because while he was living at Covey's farm, Covey's job was to break his spirit, to render him susceptible to slavery and to get him to accept his position as a slave. And for 6 months, Douglass tells us it worked. Douglass says that his spirit was broken by weekly beatings and mistreatment by Edward Covey, until one day Douglass had finally had enough and he stood up for himself. In his memoirs, he tells about how he had passed out in the August heat working in the fields, and when when Covey saw that, he beat Douglass for it. So Douglass walked 2 miles to his master's home to beg for some kind of mercy, and his master refused and sent him back to Covey, who of course attacked him a second time, whereupon Douglass defended himself, and they fought for several hours, according to Douglass, until finally Covey stumbled away, saying, "If you hadn't resisted so much, I wouldn't have beaten you." But he actually hadn't beaten Douglass. He was just trying to save face. And Douglass tells us that he learned from this the great lesson of his life, which he quoted in the line from the poet Lord Byron, "He who would be free must himself strike the blow." Upon that, Douglass decided that he had to escape to his freedom. And in 1838, at the age of 20, he managed to escape on the Underground Railroad, first to New York City, and then he was sent to live in New Bedford, Massachusetts. The reason for New Bedford was because he had worked, while in Baltimore, he'd worked helping to build ships. And New Bedford, Massachusetts was the capital of the whaling industry at the time, and so it was a good place to get a job working on ships. Unfortunately, Douglass found that the shipbuilders in New Bedford were so racist they wouldn't allow him to work there, so he had to get other jobs instead. Nevertheless, while he was in Massachusetts, of course, he met up with William Lloyd Garrison, the leader of the abolitionist movement. Now, there's a subtlety here that's important for those who aren't really familiar with anti-slavery history. We often hear people use the term abolitionist to refer in general to anybody who is opposed to slavery. And that's not accurate. In fact, anti-slavery thought went through several stages in American history. Early on, there was a variety of anti-slavery thought that was called colonialism. This is the idea that slavery should be gradually eliminated, and then the freed slaves should be sent to live elsewhere, Africa or Central America, in colonies or something. And this was a respectable form of anti-slavery thought at the time. People like Thomas Jefferson, James Madison, and James Monroe were colonialists of this sort. Then in the 1830s, William Lloyd Garrison came along, and his great accomplishment as a thinker was to overthrow this idea of colonialism and to replace it with abolitionism. Abolitionism, as opposed to colonialism, consisted of three parts. First, the immediate emancipation of the slaves, none of this gradual stuff that as had been proposed before. Two, no compensation to slave owners. There had been schemes for paying slave owners to free their slaves, and the abolitionists said no. In fact, they said the slaves should receive compensation, not the owner. And the third element was no expulsion from the country. Blacks and whites should live together in the United States, and there should be no compulsory colonialism or anything like that. And in 1831, Garrison started publishing his newspaper, The Liberator, which was his major mouthpiece for arguing for abolitionism. And he managed to essentially eliminate colonialist thinking. And Douglass, of course, had read The Liberator while in Baltimore, and he admired Garrison immensely. And he managed to meet Garrison at one of his meetings and impressed Garrison so much that Garrison recruited him to work for the Massachusetts Anti-Slavery Society. Now, Garrisonian abolitionism had certain qualities that are worth emphasizing when talking about Frederick Douglass as a constitutional thinker. We often talk about Douglass as a personal hero. I mean, he really was a remarkably heroic man, a very brave man whose life is really exemplary, but he was also a very important intellectual. And one of the goals of my book is to try and emphasize his contribution to political philosophy and constitutional thought. To understand what Douglass accomplished there, we have to start with Garrison, because Douglass, he was in his 20s, he's recruited into the Garrisonian movement. And Garrisonian thought was the Constitution is an evil pro-slavery document. The Constitution includes compromises with slavery that give it legal protection and is therefore immoral. And Garrison used to burn the Constitution at his July 4th speeches in order to cause a ruckus with the crowd. It was apparently quite a spellbinding order, and on more than one occasion was nearly lynched for this. Garrison said the Constitution is evil, and people should not vote or run for office, because to do so meant lending credibility to the corrupt constitutional and legal system. You should have no participation in the political system. Garrison was also a pacifist. So he believed that he did not believe in slave uprising or in using military force to eliminate slavery. He was essentially a Christian anarchist. And Douglass believed this. Douglass joined this movement and gave speeches to this effect. And there are quite a lot of remarkable speeches that Douglass gave early in his career about the Constitution being an evil document. And endorsing the principle that Garrison put, his motto was no union with slaveholders. He thought that the northern states should secede from the Union in order not to have anything to do with slavery. No participation in the system. Douglass was never quite a pacifist, though. And it's kind of interesting that when Douglass published his memoirs in 1845, the first version, he ended up publishing 3 versions, but the first version of his memoirs came out in 1845, and Garrison published it. He tells the story of his fight with Edward Covey. And he claims in that passage that he acted in defense only, and he claims that he didn't punch Covey or hit him. I find that rather hard to believe. Douglass was never a non-violence man. And in fact, later in life, he lionized John Brown. He thought John Brown was one of the greatest Americans who ever lived. Douglass said the way to make to make less slave catching is to make some fewer slave catchers. In other words, we should kill the marshals who enforced the fugitive slave law. And of course, when the war broke out, Douglass encouraged Black Americans to enlist in the military and fight for the liberation of the slaves. So Douglass was never a passive or a pacifist or a nonviolence man. But the real change in Douglass came in 1845 after he published his memoirs. When he did that, it identified people and places that put him at some risk. It was a possibility that Douglass might be kidnapped and sent back to slavery under the fugitive slave laws. So Garrison and others recommended that he take a trip to England and spend a year there giving lectures, which Douglass did. And while he was in Europe, he met with a number of anti-slavery thinkers in Europe who had made a lot of progress through the political system. And they changed his mind, or at least this is my interpretation. We don't have definitive evidence of this, but I think that they were instrumental in changing Douglass's attitude away from Garrison's belief that you shouldn't participate in politics. They had accomplished a lot in politics. And in 1847, when Douglass returned to the United States, his admirers in Europe had collected enough money to buy Douglass's freedom. And there was money left over, so that when Douglass returned, he had money to start his own newspaper to compete with Garrison's. And Douglass moved to New York, to Rochester, New York. And there he founded his own newspaper and came under the sway of the New York abolitionists, who were led by a man named Gerrit Smith. Now, the New York abolitionists under Gerrit Smith differed strongly from the Massachusetts abolitionists under Garrison. Gerrit Smith said that the Constitution was not an evil document. In fact, he believed that the Constitution was implicitly an anti-slavery document. He helped to lead a group of people that included Lysander Spooner and Joel Tiffany and a few others to argue that the Constitution was actually an anti-slavery instrument. There were three elements in anti-slavery, pro-constitutional thought. The first is the Constitution does not expressly protect slavery. It doesn't. It doesn't contain the word slave or the word slavery. It gives no express guarantee to slavery. The second principle was the Constitution gives Congress power to restrict or even eliminate slavery if Congress chose to do so. As they like to say, you didn't have to change a single word of the Constitution if slavery were eliminated tomorrow. The third principle of pro-Constitution anti-slavery thought was the Constitution is in the long run inconsistent with and incompatible with slavery. If you look at various provisions of the Constitution, they argued, they can't be reconciled with slavery in the long term. For example, the Constitution protects the right to due process of law, but slavery obviously violates that. It takes away people's liberty without due process of law. Now, even if you regard slavery as a private institution not created by the law, which is true, nevertheless, the government was so much invested in enforcing slavery that it inevitably violated people's due process rights whenever it enforced the claims of slave owners. Or take another example, the attainder and forfeiture clauses of the Constitution. They prohibit either the federal government or the states from imposing any bill of attainder and prohibiting forfeiture from extending beyond a single generation. Slavery was pretty obviously inconsistent with those principles. There are other provisions of the Constitution that also are incompatible with slavery. The most important one was the Privileges and Immunities Clause of Article 4. Privileges and Immunities Clause of Article 4 says that a citizen of the United States who travels from state to state cannot be discriminated against by the state that they go into. So if I'm now a citizen of Arizona, I travel to California or Texas or something, the states there can't discriminate against me on that basis. Well, prior to the Civil War, this created a real problem because before the Civil War, the Constitution contained no definition of citizen, which if you think about it is really quite remarkable. The Constitution does refer to federal citizens, citizens of the United States. For instance, you have to be a natural born citizen of the United States in order to run for president, right? And yet nowhere in the document was the term citizen defined. It was never clear how you became a citizen of the United States. Congress could pass naturalization laws for people who immigrated, but what about a person who's born in, say, New York in, 1800 or something? How exactly does that person become a citizen of the United States? Is it via his state citizenship? That was the answer that was normally given. Before the Civil War, you became a citizen if you were a citizen of the state. Then by function of that, you were a citizen of the United States, which is fine if you're white, but what if you're not? Because in Massachusetts, for example, it was perfectly lawful for a Black man to be a citizen of Massachusetts and therefore a citizen of the United States. But in South Carolina, the law prohibited a Black man from becoming a citizen of South Carolina, and therefore he could not be a citizen of the United States. And what happens when a sailor travels from Massachusetts to South Carolina on a ship? In fact, South Carolina passed a law called the Police Bill or the Negro Siemens Act that said that if a ship arrived in a South Carolina port with a Black sailor on board, the sailor had to be imprisoned until the ship left port. And the captain of the ship had to pay for his food and board. And if he didn't, then the sailor would be sold into slavery. Well, this obviously is a problem under the Privileges and Immunities Clause, right? Because here's citizens of the United States traveling from state to state being discriminated against. That presented a huge constitutional problem in the United States. Okay, so those were the theories of pro-Constitution, anti-slavery thought. But what about the provisions of the Constitution that, at least implicitly, seem to guarantee slavery, right? There are 4 of them. There is the 3/5 clause, there's the Fugitive Slave Clause, there's the clause that prohibits Congress from banning the international slave trade until 1808. And then there's a clause that prohibits any amendment of that 1808 deadline. And there's also another clause that says that the federal government can call out the militia to put down insurrections, which, at least implicitly might be a pro-slavery clause also. What about those? Well, in arguing this issue, Douglass pointed, or the anti-slavery pro-constitutional theorists, including Douglass, pointed to this. They said, first, you start with your rule of interpretation. Interpreting the Constitution, you always have to have a rule of, is it strict construction? Is it loose construction? What is your rule of interpretation? The rule of interpretation that the Supreme Court had given was, you interpret the Constitution as pro-freedom unless the opposite is clearly required. We call this a clear instruction rule, right? Or a clear statement rule. And that principle was announced by Chief Justice John Marshall. It's a very old principle. Secondly, if you have to interpret the Constitution as pro-freedom whenever possible, and you look at the Constitution for some clear statement, you don't find any constitutional provision that expressly guarantees slavery. And these 4 provisions of the Constitution can be interpreted as pro-freedom plausibly, right? The 3/5 clause, for example, doesn't protect slavery. It obviously acknowledges that slaves were in the United States at the time, but it didn't give it any constitutional or legal protection. In fact, implicitly, it rewarded states that might free their slaves by giving them more representation in Congress. What about the Fugitive Slave Clause? Well, the Fugitive Slave Clause doesn't actually use the word slave or slavery. It says persons held to service shall be returned to those to whom the service or labor is due. But Douglass said, slavery is not due, or work is not due from slaves because they've been the victims of an injustice and have not received due process of law. Instead, he says this clause can be interpreted as referring to apprentices or indentured servants. And it is true that apprentices running away from their masters was a very big legal problem in the 19th century. So that is a plausible interpretation. And the prohibition on the slave trade didn't protect slavery. It simply gave a deadline when Congress could ban the slave trade, which Congress did ban on the very first day that it was allowed to do so. So under this theory, the Constitution does not guarantee slavery. It is in the long run incompatible with slavery, and it gives Congress the power to eliminate slavery. Douglass was persuaded by this theory, and in 1851, he published an article called Change of Opinion Announced, where he repudiated his previous Garrisonian beliefs. And this led to a split between the two that they never reconciled in their lives. Now, that was the 1850s. At that time, of course, this is all coming to a head, right? The Dred Scott opinion is announced in 1857. So all these constitutional and legal arguments are becoming very important. While the anti-slavery constitutional theory is regarded by many people today as implausible or unpersuasive, in fact, it's rarely even taught in law schools or colleges, it's really not any less persuasive or convincing than the pro-slavery theory of the Constitution is. Douglass likes to point this out. He likes to say, if you're pro-slavery, you bear the burden of proving that the Constitution protects slavery. It doesn't contain any reference to slavery directly, so you bear the burden of proving the Constitution is pro-slavery. And because the Constitution contains no explicit protection for that, you're in the position of a person who's claiming to own property under a deed that never describes that property. So that's very implausible to begin with. What was the pro-slavery theory? Well, the greatest advocate of pro-slavery constitutionalism was the South Carolinian John C. Calhoun. Calhoun's argument went like this. First, the Constitution does not create a sovereign single entity to govern the United States. It is instead a treaty among sovereign states. The sovereignty of the United States rests in the state capitals, not in Washington, D.C. The Constitution is a treaty or a league between them. That means, Calhoun says, there is no such thing as a citizen of the United States. There are only citizens of the states. And on top of that, Calhoun argued the Declaration of Independence is literally a falsehood. He called it a lie in his famous Oregon speech in 1850. So that means that the United States is a white supremacist nation created only for white people, and that the states have this sovereign authority to decide who is free and who is not, and the federal government and the federal Constitution put no limits on that. Now, of course, in Dred Scott, the Supreme Court approved of a modified version of this Calhounian theory of the Constitution and declared that slavery was expressly protected in the Constitution, which is, of course, literally a lie. I mean, the Constitution does not, whatever you think, it does not expressly protect slavery. At most, it does so implicitly. And of course, that set the stage for the showdown that began the Civil War. Douglass, when the South seceded from the Union, Douglass saw that as proof that he had been right, because it was the pro-slavery side that had to abandon the Constitution in order to protect slavery. And they did so because the newly elected president, Lincoln, had said that he was going to prohibit slavery from reaching the Western territories under the constitutional authority that he had. So Douglass saw that as a vindication of the pro-Constitution anti-slavery movement. And when the war ended, the anti-slavery thinkers who were in power by the time the war ended were of this school of pro-Constitution anti-slavery thinkers. People like Charles Sumner, for example, the famous senator famously beaten on the floor of the Congress because of his anti-slavery view. These people were pro-Constitution anti-slavery thinkers like Gerrit Smith, like Frederick Douglass had been. And they took the opportunity at the end of the war to pass an amendment to the Constitution to ensure that their ideas would forever be enshrined in the Constitution. And that was the 14th Amendment. I think a lot of the time when we look at the 14th Amendment, we think of it as designed to radically change how the Constitution worked. That's not how the framers of the 14th Amendment thought of it. They thought of it as clarifying that what the Constitution already had always meant all along. They had always thought slavery was unconstitutional. They had always thought that Black Americans were citizens of the United States, entitled to protection for their individual rights. So they thought of the 14th Amendment as rescuing the Constitution from misinterpretations that had been foisted on it. How does it do that? First, it guarantees citizenship. Every person born and naturalized in the United States and subject to the jurisdiction thereof is a citizen of the United States and of the state wherein they reside. Now, that's an interesting line for a number of reasons. First, it finally defines citizenship, right? I said the Constitution never defined citizenship. Now it finally does in 1868. Secondly, it's a citizen of the state you live in, regardless of what that state says, right? About 5 years ago, I moved from my native state of California to Arizona, where I now live. and I became an Arizona citizen, and nothing Arizona had no say in the matter, and nothing Arizona can do can make me not an Arizonan. Well, that's remarkable because that eliminates any pretense that states are sovereign. You can't be a sovereign if you can't define your own citizens. So that eliminates even the pretense of state sovereignty. Then it guarantees your rights to due process against interference by the states, something that had not been done before. And it creates a new privileges or immunities clause that's valid against the states and prohibits states from depriving you of those rights. So the 14th Amendment is really a vindication, a memorialization, you might say, of the pro-Constitution, anti-slavery theory that Douglass was one of the most eloquent and interesting spokesmen for. And of course, after the war, that did not at all end Douglass's career as a political leader. He also was one of the foremost advocates for the 15th Amendment to guarantee the right to vote for the freedmen. Now, this was a heroic moment on Douglass's part, but a lot of the time it's kind of misunderstood. Douglass did not see voting rights the way that we often see them today. A lot of time today, people speak of voting as if it's some sort of almost mystical communion with the collective. That voting is the most important right because it's your democratic participation in the body politic, and all this sort of romantic notion about voting as us creating our ideal society. That is not how Douglass spoke of voting rights. Douglass saw voting rights as a form of self-defense. He said Black Americans need the right to vote in order to defend themselves against those who would violate their rights, against the former Confederates in the South and so forth. And for the same reason, Douglass was a very eloquent spokesman for gun rights. Douglass insisted that Black Americans should own firearms. One of my favorite lines from Douglass is that citizenship rests on 3 boxes: the ballot box, the jury box, and the cartridge box. Douglass was very insistent that Black Americans should be armed so that they can defend themselves. And also for another reason, and that is, I think Douglass's most significant contribution to political philosophy is his principle that self-esteem is essential to political liberty. If you look at the history of classical liberalism, or what we now call libertarianism, you don't really see this idea before Douglass. Today, probably the most famous spokesman for this idea in today's world is Ayn Rand, who argued that self-esteem is a crucial element of a free politics. But Douglass, who only died about a decade before Rand was born, Douglass was the most outspoken and I think the earliest prominent American spokesman for the idea of self-esteem as connected to political liberty. A great example of this is a speech that he gave during the war, encouraging Black Americans to enlist in the military. What's interesting about it, it's called "Why Should a Black Man Enlist?" And he gives 7 or 8 reasons. And what's interesting about it, nowhere in this speech does Douglass say you should join the army to serve your country, right? That's the most common refrain nowadays when people talk about joining the military. Never does Douglass say that. In fact, of course, Douglass would have regarded that as absurd, right? Slaves had been abused by the country to such a degree that they owed nothing to the country. It was absurd to suggest that they owed something to the country. On the contrary, when you read Douglass's explanation, he says you need to get guns in your hands to defend yourself, and you need to join the military to feel a sense of accomplishment and achievement, because he says your masters have abused you so much that some of you have started to even doubt your own selves. And who, again, his favorite refrain, who would be free must himself strike the blow. So you have to build a sense of self-esteem and achievement in order to have that pride that will enable you to live fully as a free person. That's Douglass's greatest, I think, accomplishment as a political philosopher. His second most important principle, aside from this self-esteem issue, is his insistence on the citizenship rights of Black Americans. What I mentioned at the beginning, that one thing that abolitionists did as opposed to colonialists is they insisted that Black Americans should not be expelled from the country. And this never changed in Douglass's life. He was insistent that Black Americans were American citizens entitled to live in North America alongside whites and had no obligation and no interest in leaving the country. And the reason this was important was because it wasn't just whites who insisted at the time that Black Americans should be sent to the colonies in Africa or something like that. Black Americans themselves, many Black Americans also argued that they should leave the country. Probably the most important of these is Martin Delany, who was a close friend of Douglass. Douglass named one of his sons after Martin Delany. They worked together on the newspaper for a while. But when Delany insisted on the idea that Black Americans should leave the country, Douglass broke with him and would have nothing more to do with him for that reason. And even toward the end of his life, when many people were giving up on the idea of equality in the United States, Douglass insisted that Black Americans should stay in the country. They had the right to do so. They should not surrender to the claims of white supremacists. In the 1890s, he spoke at the World Columbian Exposition in 1893. And during his speech, he said, "All this native land talk is nonsense. The native land of the American Negro is America. His blood and bones and sinews are American." That really puts him at odds, I think, with a lot of today's Black intellectuals who argue that America is a white supremacist nation, who agree with Garrison that the Constitution was a pro-slavery document, and who claim that Black Americans really have no future in white supremacist America. Douglass rejected that at the time, and I think would do so to this day. So I've given you a few minutes on some of the most interesting. Let me wrap up with one other thing, and that is the toward the end of his life, the 1890s. So after the war ended, of course, the restoration of white supremacy in the South led to things like lynching and the disenfranchisement of Black voters in southern states, and this was really a dark cloud looming over the country. Fortunately for him, Douglass died a year before Plessy versus Ferguson was announced. It's a good thing he didn't have to see that, right? But Douglass went to his grave as an advocate for equality and for the principles that Black Americans were entitled to the rights of the Constitution and the Declaration of Independence. And probably one of his most controversial things that he ever did was late in life married a white woman, and a woman named Helen Pitts, at a time when that was, you can imagine how scandalous that was in the 1880s. Douglass loved to kind of tease white people this way. And on one occasion, he went to the White House for a reception, and he had his daughter take his arm to meet the president, and his wife walked behind him. That way, when the president would greet his daughter and say, "Oh, it's nice to meet you, Mrs. Douglass," Douglass could correct him and say, "Oh, no, Mr. President, that's my daughter. This is my wife," just to kind of get a rise out of him. When Douglass was an old man, there's an old legend that a young man came to visit him at his home in Washington, D.C. and said, "Mr. Douglass, what should I do with my life?" And Douglass's answer was, "Agitate, agitate, agitate." I think that's a good way to end my comments and see what questions any of you might have.
All right, thank you, Mr. Sandefur, for your comments to this point. We will open up the floor to questions. So if you have questions, you can throw those in the chat, or you can use the raise hand function, I think. Let me see if I have that open. I do. So if you can raise your hand or put questions in the chat, that would be great. I think I'll ask my ancillary questions about other characters in the story later, but did Douglass see the 14th Amendment as a restatement of the Constitution as it stood already, the way the, I guess we'd call them the radical Republicans did, or did he see it as doing something more?
Yeah, I think he definitely saw it as a restatement of what he had believed was always the constitutional rule. And, for one thing, we have his thoughts on the Slaughterhouse Cases of 1873. In 1873, the Supreme Court issued a decision called Slaughterhouse that basically erased the Privileges or Immunities Clause from the 14th Amendment. And Douglass wrote a letter to Gerrit Smith complaining about this, of course, and saying that the principle should be one nation, one citizenship for all, instead of what the court had said, which was that there are these two different categories of citizenship and you don't have protection in one situation or the other. But Douglass's interpretation of the 14th Amendment, here's what I think is one particularly interesting aspect of it. So in the 1880s, the Supreme Court issued a decision called the Civil Rights Cases. it struck down the Civil Rights Act, and it had only one dissenting opinion, and that was Justice Harlan, who also dissented in Plessy versus Ferguson, whom Douglas said should run for president. And that case is the articulation of what we call the state action doctrine, right? The Civil Rights Act had prohibited private discrimination as well as public discrimination. The Supreme Court said Congress has no authority to do that. The 14th Amendment only prohibits discrimination by the government, not by private persons. And therefore, Congress has no authority to intrude on the private contractual decisions of individual property owners and so forth. This, of course, was long before the Supreme Court came up with the idea that the Commerce Clause could be used for those purposes. So Douglas gives a speech about the civil rights cases where he attacks this idea of the state action doctrine. And he says it makes no sense that, for instance, a sheriff can discriminate as much as he wants when he takes his hat off. And then when he puts his hat back on, all of a sudden, all the guarantees of the Constitution apply to him. He says, what is a state but the people who make it up? Otherwise, it's just rocks and trees and rivers. The whole idea of the state is the people who make up the state. So it makes no sense to draw this line based on state action. It's a very interesting argument. I'm not sure, I don't think I'm persuaded by it, because I think the state action doctrine is an essential way of preventing the government from dictating every choice that we make in our lives, honestly. But it shows that Douglas was a very much an original thinker when it came to interpreting the Constitution, which is pretty remarkable. I mean, this is a man who had literally no schooling, and yet he was able to make these constitutional arguments to a level of sophistication that is quite impressive. To get back to your answer, I think the answer is Douglas definitely saw the 14th Amendment as a vindication of what the Constitution, he thought, had always declared. The 15th Amendment, I think he did see that as more of a change. That was a situation where it was they really were creating something that didn't exist before, the right to vote. But Douglas argued that Black Americans were citizens in the 1840s. In fact, Douglas himself had an effect that when Douglas was traveling in Europe on one occasion, he requested a passport from the Secretary of State so that he could visit Paris. And that was denied to him on the grounds that he was not an American citizen under the Dred Scott opinion. So he was personally affected by these in his daily life. It's really quite remarkable.
Thank you for that, Professor. I think that clears a lot of that up and also reinforces a lot of con law too. So helpful just to get that history.
A law that is often ignored in the classroom. I think it's a real shame. I know I graduated from law school without ever hearing a word of anti-slavery constitutional thought. It was just not taught. And I went to a very conservative law school. So it's a shame that this is left out of our curriculum.
I wanted to kind of just build upon his opinions of the 14th Amendment. And you had mentioned the Privileges and Immunities Clause, how that was dealt with in Slaughterhouse, or rather not dealt with. But how do you think he would have seen substantive due process? Or did he have any comments about that in his life?
Off the top of my head, I don't think I recall him referring specifically to the doctrine, but this is important to talk about because I think Douglas would have taken it for granted that substantive due process was a legitimate doctrine. Here's the myth that you will often be taught in law school. You'll often hear that Dred Scott was the first time the court used substantive due process. From what I gather, this lie originated in the 1980s in a book called Democracy and Distrust by a man named Ely. And it's a lie. Substantive due process is a principle that reaches back to the memory of man runneth not to the contrary, as the common law lawyers used to say. It's just that before the 1930s or so, it was not called substantive due process, it was called due process. The way substantive due process works is this: if the government has no authority to do something, then its enforcement of an unlawful statute against you is not the enforcement of a law, right? Suppose that, and therefore violates the due process of law, right? So suppose Congress passed a law that says Scientology is now the official religion of the United States. Everybody has to go to the Scientology church on Sunday. I don't know if Scientologists go to church on Sunday, but whatever. And say every Sunday you have to go to the Scientology church, and you refuse to go, of course, because the First Amendment prohibits that. So the sheriff comes and he knocks on your door. He says, "Why aren't you in church on it's Sunday? You're supposed to be at the Scientology church." And you say, "No, I'm not. And I don't have to be there." And the sheriff says, "Well, yes, you do. Congress passed this law that said," and you interrupt him. You say, "No, you can't say that. Whatever Congress passed, it didn't pass a law forcing me to go to church, to the Scientology church on Sunday, because Congress shall make no law respecting the establishment of religion. Therefore, whatever Congress passed cannot qualify as a law, and therefore for the sheriff to arrest you would be a deprivation of liberty without due process of law." That's what substantive due process means. It's very misleading because we refer to it as the due process clause. What we ought to call it is the due process of law clause, because those are the two really important words, due process of law. What the clause says is government has to operate according to principles of law. What are principles of law? Well, not only are they the express provisions of the Constitution or the statutes or whatever, but there are also certain implicit principles that make a law into a law instead of some other thing. For example, you might have read the famous case of Clinton versus New York that prohibits the line item veto. Why? Because the Constitution says how a bill becomes a law. No alternative method is allowed. Therefore, the line item veto violates that principle. Therefore, it is not a law. Therefore, it is unconstitutional, right? The same principles apply to implicit principles of logic, right? What about a law that both required and prohibited the same thing? Would that be a law? No, it would be gibberish. What about a law that was literally gibberish? That was just a string of meaningless symbols and letters that was passed by the legislature. Would that be a law? Legal positivists, people like Orrin Kerr, for example, have to answer that question, yes. But the right answer is no. Of course, it's not a law because it's a meaningless document. And for you to be arrested under it would be to deprive you of due process of law. And that was taken for granted in the 19th century. The earliest exposition of it that I found is Daniel Webster's argument in the Dartmouth College versus Woodward case. And it was taken so much for granted that the one sentence of it, or of the Dred Scott opinion that refers to substantive due process, nobody complained about it. Even Lincoln agreed that that was correct. So the myth that substantive due process somehow originated in Dred Scott and is somehow tainted with the history of slavery, that's a lie that has been propagated for political reasons, because it's very convenient for both conservatives and liberals to claim that substantive due process is somehow wrong. That's a long roundabout discussion, but I thought that it's important to get that message out.
Thank you for that. That's definitely something I have not heard, just described in that way. I've heard the pros and the cons, but not in that way. So
I will encourage you to get my brilliant book, The Conscience of the Constitution, with its very helpful chapter in defense of substantive due process.
Well, it's very seldom we get to pump two books in the same event. So thank you for that. I have a question from the chat. It says, if Douglass was alive today, what ideas might he have to unify the country and ensure its founding principles endure?
I think Douglass had a way of speaking that is what they call the Jeremiad nowadays. And the term comes from the Bible and the prophet Jeremiah, who went about reminding people of the principles that he believed they had forgotten. And Douglass, I think if he were alive today, that he would do that. I think he would insist on the moral rightness of the Declaration of Independence and the Constitution. He would understand why something like the 1619 Project says what it says, but he would emphasize that in claiming that the Constitution is a pro-slavery document, that the writers are giving away the entire moral high ground and are adopting the pro-slavery theory of John Calhoun and others who argued precisely those same things, that the United States is a white supremacist nation and so forth. And Douglass would insist on that those things are wrong. As far as bringing Americans together, you know, Americans were far more apart in his day than they are today. And it's easy for us to forget that, I think, for us to look around us and see how all hell is breaking loose and think things have never been this bad. And I think Douglass would say, you know, we had things much worse in our day, so count your blessings. Obviously, there's still plenty of work to be done. But I think that would be his number one thing, would be to insist on understanding the Constitution and the Declaration and on the rightness of its principles, the universality of those principles. In his final speech, Douglass, I think it was his final speech, he said, there is no Negro problem. The problem is whether the American people have the honesty enough and the courage enough to live up to their own Constitution.
Thank you for that, Professor, or Mr. Sandefur. We have a question from the floor. Tony?
Yeah, I just had a question. And I'm not a law student, I'm a medical student, so this might be a simple question, but I think the most frequently I hear about Frederick Douglass, or whenever it pops up every year, is just like quoting his 4th of July speech. Like that's the most prominent thing I hear. When I hear it quoted from those like across the political spectrum, what do you think we miss when we just take, like, I hear little excerpts here and there? What was his overall point of that speech? And are we missing the point when we, you know, pull a sentence or two here out of it?
Oh, that's a great question. You're absolutely right. Not only that, but this really bothers me. Check this out. So if you get the Library of America edition of Douglass's memoirs, it includes an excerpt from that speech, but only an excerpt from that speech. And a lot of people read it and they think that's the whole thing. And the reason that's really frustrating to me is because the speech is 2 parts, basically. The first half of it, Douglass says, look at how horrible and evil slavery is. And then the second half of it, he says, the Constitution is an anti-slavery document. And people, that second part isn't in this book. And so people read it and they never hear that part. It's really upsetting me. Yeah, the speech, which is also frequently called The Meaning of the 4th of July to the Negro, or What to the Slave is the 4th of July, is one of Douglass's most famous speeches. His famous speeches are his speech at the dedication of the Freedmen's Memorial in Washington, D.C., which was probably the biggest speech he ever gave. The audience included the president and the Supreme Court and senators. It was a big deal when he dedicated that monument. And it's a very interesting speech because it's his unvarnished thoughts about Abraham Lincoln. You know, dedicating a monument to Lincoln, you would expect him to praise Lincoln to the skies, and he doesn't. He says Lincoln was preeminently the white man's president. And he gives a very measured and interesting view of Lincoln. It's very much worth reading. His most famous speech at the time, during his lifetime, was called Self-Made Men, and he delivered it 50 or so times in his lifetime. And it was sort of an overview of the virtues of self-reliance that give birth to the entrepreneurial, self-made character of the American dream, basically. And then the 4th of July speech. Those are probably his most famous speeches during his lifetime. The 4th of July speech all of his speeches are written in this very beautiful 19th century style. It's a little hard sometimes for people nowadays to read it because it's very rich in its language and its vocabulary and in its references, right? He quotes the Bible and Shakespeare constantly and Victor Hugo and all these sorts of things, just assuming that you will recognize them. And a lot of people don't nowadays, so it takes a little work sometimes. But they're beautiful and they're just marvelous to read. I can't recommend strongly enough to read Douglass's speeches. People often read his memoirs and they fail to read his speeches and his articles. It's really, I can't emphasize enough how important it is to read his articles. The 4th of July speech is this deep denunciation of the evils of slavery and how slaves are mistreated and how the Black American is discriminated against. And yet, the Constitution promises us so much, and we have a right, we have a claim on the Constitution, he says. And in a way that you could say it's kind of the open bookend to the I Have a Dream speech by King, right? The I Have a Dream speech, King says the Declaration of Independence is a promissory note And he says, we're here to cash in on that promissory note. And Douglass is the first who really says, this is a promissory note. He says, we are entitled as citizens of the United States to these rights, because this speech predates the Dred Scott opinion. So I very much urge you to read the whole speech. You can get it online, or you can get this book, which is the one that I recommend most of Douglass's speeches. This is edited by Philip Foner and Yuval Taylor, and it is the largest single volume collection you can get. It's got its problems, lots of typographical errors, but the other books of Douglass's speeches leave out a lot, and this one is probably the best you can get.
Well, Tony, thank you for the question. Excellent answer also. And I think if anyone is interested in the comments to this video, when we post it to our YouTube page, we may inaugurate a Tim Sandefur collection of books to read. We're getting a lot of reading material out of this. So I did have one other.
In my office, I have my Douglass shelf. If I were doing this from home, I wouldn't have access to all these, but my whole Douglass shelf is right here by my feet. So.
Excellent.
I just want to say I've read Mr. Sandefur's Douglass book, and I highly recommend it. It was my first dive into Douglass, and it's short, very, very readable, but like super educational. So I really appreciate that read.
And a dust jacket endorsement. We're hitting it all. I did have a question just to tie things into current day culture and just some references other people may recognize if Victor Hugo and the Bible are sort of out of the common sphere at this point. I'm looking at these quotes, the first blow quote, the idea that he was a self-made man, very much about self-esteem, the speech to the recruits, the black recruits for the Union Army. Is he a Hamiltonian gunner? Is that his sort of like fame through action sort of person, or is this more tied, were his ideas more tied to this constitutional political thought?
Fame through action, that's an interesting thing. You know, I'm sure there's a little bit of that. I mean, when I mentioned Victor Hugo, for instance, you know, Hugo was one of his favorite writers. His very favorite was Alexander Dumas. Douglass was very much into the romantic novelists of the 19th century. And so he loved the idea of these strong individuals who stand for principle, who don't compromise their principles. I mean, he believed in compromising, you know, in the sense of cooperating, but he didn't believe in compromising principles. He believed in the sense of dignity and nobility very much. I mean, one of my favorite stories was when Douglass went to the White House for the first time. Of course, no black man had ever met the president. And so he goes in the White House and he's led into this waiting room where there's all these lobbyists sitting around waiting for their opportunity to meet with Lincoln. And while he was standing there, this guy comes up to him and in this, you know, the kind of the ordinary racism of the day says to him, are you the president? Like, isn't that funny, you know, that you know, Douglass would be the president. And Douglass just looked at him and said, I am Frederick Douglass, which I just love. I mean, that's just the perfect response, right? I don't have to be anybody other than who I am. Aside from the fact that Douglass was a world famous writer and orator by that time, more famous than Lincoln in many ways. In fact, there's the old story that after Lincoln's second inaugural address, he came down and saw Douglass in the crowd and he asked Douglass, what did you think of the speech? Well, Lincoln really wanted Douglass's approval of the speech because Douglass was such a famous orator and Lincoln wasn't. So it really was, I mean, he's looking up to Douglass, not the other way around. So I think there is an element of that about Douglass, that he wants that to cut that figure. Douglass was also, incidentally, the most photographed American of the 19th century. He loved having his picture taken. They've actually published a book. There you go. They published a book of just the photographs that he took during his lifetime. So he cut a figure, and he saw that as a responsibility, I think, in order to show the world that a black man could be a dignified and respectable and honorable figure at a time when many people doubted that. So there was a bit of that. On the other hand, the man and the mission merged, right? Douglass didn't do it just for the fame by any measure. I mean, Douglass did these things because he so devoutly believed in them. And that, that is a sense in which that's a limitation, right? Some people, somebody like Lincoln was a superior leader because he made the compromises necessary, got his hands dirty, whereas Douglass could cut the bold, heroic figure and not do that, which in some sense is easier because then you don't have to negotiate with the other side and that sort of thing. There's a case to be made there. But I think for Douglass, self-esteem and the mission merged to such a degree that it's almost senseless to ask if he did it for purposes of fame. The man and the mission were inseparable, which incidentally kind of made him a hard guy to live with sometimes.
Mr. Sandefur, thank you for that answer, and thank you for your time and expertise today. We've learned a lot. We've gotten some good book references and ideas for further reading. I'm going to have to brush up on my Victor Hugo before I read some Douglass, I think. But thank you again so much for your time. If anyone's interested, you can look up Mr. Sandefur either by the title of his book, Frederick Douglass, Self-Made Man, or at the Goldwater Institute. And also this video will be on our YouTube page, and I'll send out that link after we post it. So thank you so much for your time, everybody. And Mr. Sandefur, have a great night.
You too.
Thank you very much.